All right, this is case number 21CR43, State of Ohio versus Ellen, and I believe it's pronounced Dugman, is that correct? You're muted there, ma'am. Can you, the deputies there, have them unmute you? There's a little button down in the corner. Okay, that's got it. You're, is it Evelyn Dugman?
Yes.
All right. Mrs. Dugman is appearing by video from the jail. Oh, I don't see a prosecutor yet.
We're here, Judge.
Oh, okay. I was looking on here at the Conrad one. I'm sorry. All right. So Mr. King and Ms. Collins are present here in the courtroom. The defendant was convicted of breaking and entering a fifth-degree felony. It was put on community control on October the 20th. There was a notification filed on, I believe, February 5th, that she had violated the conditions of community control. Court informed her of those allegations, appointed Mr. Kirk to represent her, set the matter for a hearing this morning, or this afternoon. Now, who's going to handle it? Mr. King,
Yes,
has the victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Your Honor, a representative has been notified and he's elected not to appear.
Okay. All right. Mr. Kirk, have you had an opportunity to review the allegations that were filed on February the 5th by probation department?
I did, Your Honor. I went out about 2 days ago and met with Ms. Topman at the jail. She's indicating to me she wants to admit, however, I am concerned about her competency at this time and her mental health, so I'm not sure that any admission she makes would be knowing and voluntary today.
All right. Has she been seen by anyone at the jail regarding her mental health?
Not that I'm aware of. I did speak with the probation department, and they are struggling to figure out an appropriate provider that could help her. I believe they did ask Side of Paint Valley to come out, but I'm not sure if Side of Paint Valley's been out yet or not.
Mr. Bolser's here from the probation department. Do you know what?
Not yet, Your Honor. Ms. Sturgill is in the courtroom if you need further.
I'm sorry?
Ms. Sturgill is here today if you need further.
Oh, Ms. Sturgill? Okay. And so Officer Kelly signed this, but yeah.
Yes, Your Honor. She has been referred for Side of Paint Valley for further assessment and consultation, but they have not yet made it out there to do that.
All right. When did you talk to them?
Last week sometime.
All right. All right. Well, I'll continue this then until February 29th at 1 p.m. I'll order that defendant be evaluated by Soda Paint Valley Mental Health to determine her mental status as well as any possible treatment. And then you'll remain in custody till that happens, Ms. Dugman. All right. And when they come out, just make sure you talk to those folks. They'll be talking with you to try to see if there's anything they can do to help you, okay?
Okay.
All right, thank you.
Thank you, Your Honor.
All right, this is case number 23CR217, State of Ohio versus Joshua Kern. Appearing on behalf of the states, Prosecuting Attorney Collins, Assistant Prosecutor King. Appearing on behalf of the defendant's Attorney Thomas Kidd. And you are Joshua Aaron Kern.
Yes, Your Honor.
All right. Defendant has entered a plea of guilty to counts 1 and 3. Excuse me. Oh, okay. I got you. Okay. All right. The first count was abduction, a third-degree felony. Third count was domestic violence, a first-degree misdemeanor. The matter was referred to the probation department for a pre-sentence report, which I have reviewed, and if each of the attorneys had the opportunity to review a summary.
The state has your honor.
Yes, Your Honor.
All right. Now, has the victim or victims of the two counts been notified of the hearing and the opportunity to be present to be heard?
She has your honor and is present.
Is present. All right. Anything the state would like to present regarding sentencing?
Your Honor, we would ask the court to follow the joint recommendation as outlined in the plea agreement, and as stated before, the victim is present, and she would also like to make a statement.
All right. And if you would like to stand and identify yourself for the record, please.
Caitlin Kern.
Okay.
The actions that Joshua decided to make on November 6, 2023 have affected my life in a way that I can hardly put into words. The man that I married, the one that was supposed to protect, love, and cherish me, caused me severe trauma. My best friend, my husband, my person. I never would have imagined that he would do that to me. His actions have caused me not only to lose him, but both of the children involved, in which I truly do love and adore. I have nightmares about what's happened. I have dreams about the kids and reuniting with them, and waking up alone in my house, breaking down in tears and horrible thoughts that go through my head. I had to completely start my life over. I lost everything. My home, my family, my self-worth, my dignity, and all the faith that I had in myself. I've been beaten down to the lowest of lows. As a business owner in a small town, I have been criticized by my peers, my employees, my friends, and my family. No one understands what it's like to have to go through what I have, and I hope that no one ever does. I would never wish this pain upon anyone. Not a day goes by that someone doesn't ask me about him, reopening the wounds that I'm trying so desperately to heal. I'm unable to wear any clothing that remotely touches my neck. I panic and I cut the neck of my clothes, and I have no other option in that moment. I have trouble sleeping, eating, and any motivation to get better for myself or for my loved ones. I have lost around 25 pounds with the inability to eat, as I have absolutely no appetite. I have no reason to keep pushing forward but for myself, and as much as I would love to say that that's enough, I'm still not to that point that if I want to be honest. I started therapy in late January to help cope and work on how I could take things as happened and turn them into positives. I will say it has helped me in ways I never thought it would, and I'm thankful for the support system that I've had in this part of my life. I'm living day to day and sometimes hour by hour. I will never fully understand why this has happened to me, and that's okay. I deserve happiness. I deserve to come out of this stronger than I was before. I deserve the life that I so desperately want with him. I know all these things to be true, and I will make it happen for myself. I'm just not there yet. I know one thing, I'm not a victim, I'm a survivor.
All right, thank you. Anything further from the state?
No, Your Honor.
Mr. Kidd?
Thank you, Your Honor. And I just want to make sure that the court had an opportunity to review the sentencing memorandum that was filed Tuesday this week. Thank you. And we also are asking that the court accept the joint recommended sentence. Only briefly, Your Honor, I think it's safe to say that Josh never expected to be in this position. There's nothing in his background that would show that he would be in a position before you today, actually requesting a joint sentence, a jointly recommended sentence of 24 months in prison with the possibility of judicial down the road. Your Honor, not only is there nothing in his background, in the letters that he submitted from the president of Champion Bridge, his long-term employer, having worked there for over 10 years, was a glowing letter. The mother of his children as well, Sydney Ellison, provided a letter saying that this is so out of character in regard to who Josh is and how he has behaved previously. Your Honor, what Josh knows is that he doesn't want this to happen again. He has engaged in some alcohol counseling to the recovery center. He's gone to 4 classes so far. He will continue to pursue whatever is available to the DRC with that CRC and whatever his destination institution is. He wants to get back. He wants to be the father, the very active father of his 2 children, who he will greatly miss during this time. So again, we are asking that the court would impose the joint recommended sentence of the plea agreement, and I do believe my client has something he'd like to say as well.
All right. Mr. Kern?
I would like to say that I am truly sorry for all the pain and grief my actions have caused to Caitlin and all the people around us. My actions weigh heavy on me and leave me deeply disappointed in myself. Regardless of the circumstances, I know what I did was wrong, and focusing on the ripple effects of pain my actions have caused, saying sorry will never be good enough for what I've done.
All right, well, Mr. Kern, the offenses that we have here, the ones of misdemeanor domestic violence, but the abduction's a 3rd-degree felony. That's a serious offense. It's an offense of violence. And, you know, I have people in here all the time who fit the description you do. Well, I've never been in trouble before, and there's nothing in my background to suggest that I would. Well, you know, that's not what matters. What matters is what did you do? And you know, I know that you were intoxicated, but I can tell you that intoxication doesn't cause violence. It may be present, it may lower inhibitions, but you know, I had a person tell me one time, said, you know, getting drunk doesn't show a different side of you, it shows the real you. So you have a problem. You have indicated you're taking steps to deal with it, and I hope that you're sincere about that. But, you know, unfortunately, in my career, which will be soon 48 years in April, you know, seldom have I seen people that have abused women, men that abused women that did it once. I hope that this is a one-off, but this never happens again. But it's a serious matter. And that's why it carries a serious penalty. So you have taken responsibility for that and have, at least during the pendency of the case, taken some steps to deal with some of these issues. And so, you know, the court, taking that into consideration, is going to accept the recommendation. So it is the order of the court, as to the sentence, it is the order of the court that you be sentenced on count 1 to the Correction Reception Center in Orient, Ohio, for a period of 24 months, and on count 3 to a term of 6 months in Highland County Jail, and by law that is required to run concurrently with the sentence on count 1. Now, according to the sheriff, you were arrested on November the 6th and released on December 11, is that correct?
Yes, Your Honor.
All right. So that's 35 days of jail time, correct? Now, if you are not granted judicial release, and there's no promise, you know, from the court that you will be, but if you are not, and you serve, or if you should be granted it and then return to prison to serve the full sentence, upon completion of the full sentence, the law requires that you be placed on post-release control for a period of at least 18 months, up to a maximum of 3 years with regard to count 1. And that means you'll be supervised in a term set by the adult parole authority by a parole officer. And if during that period of time they determine that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a limit or cap of half of the prison term, which in this case is 24 months, so half of that would be 12 months for multiple violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. There's no restitution.
No, Your Honor.
All right. Now, you're also ordered to pay the court costs, which judgment, grant, and execution is ordered. And if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, other assets you may have. If that doesn't collect it, then upon completion of your sentence, not while you're in prison, but once you complete it, you could be permitted to do community service in this county, and you'd be given credit for each hour of community service in an hourly rate set by the court. And each hour you work would reduce your judgment by that amount until that's paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody.
May I approach, Your Honor?
May I approach?
You may. Present for the state is Prosecuting Attorney Collins, Assistant Prosecutor King. Present for the defendant is Attorney Dennis Kirk. You are Thomas J. Cordes.
Yes, sir.
All right. Mr. Cordes has entered a plea of guilty to theft from a person in a protected class, a 5th-degree felony. The matter was referred for a pre-sentence report, which I have received, and have each of the attorneys had an opportunity to review a summary?
Yes, Your Honor.
I have, Your Honor.
All right, and has the victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
He has been and has elected not to appear.
Hold on. Sir, you get yourself back in the seat. Don't ever approach a deputy from behind dealing with a prisoner again.
I'm sorry.
You sit down and
I didn't know what to do.
Okay, well, I can tell you what you're going to do. You're going to give it to him, and that's a $25 fine for it going off in court. There's a big sign posted right outside the door, turn off cell phones. So he'll, once you pay the $25 fine, you'll get it back. All right. Now, you say the victim is not present.
Is aware and is not present.
All right. Now, I noted from the report that the defendant did not report for his pre-sentence interview. I believe that's correct. And has been having some sporadic attendance at his counseling sessions. And so I don't have much information here, but Mr. Kirk, do you have anything you'd like to say regarding that matter?
I'm not aware of any current counseling that he was ordered to be in. He, according to PSI summary, and then what speaking of my client, he's regularly reported to probation, except for whatever reason, did not attend that PSI appointment. I found out about that yesterday. I called Mr. Cordes immediately and told him he's got to get up to the probation department. He advised he did go yesterday, and they told him it had already been turned in, which would be a true statement. So I'm not sure why he did not go for the PSI interview itself.
All right, well, what I have here from the probation is has not reported since the 1st. That'd be 3 weeks ago. He had his interview scheduled on the 23rd, missed that appointment, rescheduled on the 1st, showed up, didn't have the packet, was scheduled again for February the 6th and didn't show up, and has made no attempt to contact the office. So what I'm going to do is this. I'm going to order that the defendant's bond be revoked and he be committed to jail. And we will continue this sentencing until the 28th at 1 p.m. And I'm going to order that the defendant be assessed for a star because it looks to me like what we have here is an issue about attitude. And he has been negative so far on his screens, but he's been very iffy. He had asked for drug court, and he was, I believe, already sent to treatment, and so according to the assessment by the drug court coordinator, he was to complete an assessment, but as of the 20th, they had not received that. So he's not been compliant with that either. So make sure that it gets done. You're going to jail, Mr. Cordes, till next week, and then we'll decide what's going to be done. So the matter will be continued until then. All right, you're remanded to custody.
Mr. Kirk, I'm going to approach Your Honor.
Okay? Put us on bench mode.
Yes, Your Honor.
All right. This is case number 21 CR 152, State of Ohio versus Ryan F.T. McClure. Present for the states, Prosecuting Attorney Collins and Assistant Prosecutor King. Present for the defendant, Dennis Kirk. And you are Ryan F.T. McClure?
Yes, Your Honor.
Right. And has the victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Your Honor, we've attempted to make phone calls to this victim. It's been over 2 years since we last spoke to him, and we've not been able to make contact with him.
All right. All right. The defendant was put on intervention in lieu of conviction on 1/5/22, I believe it was, for receiving stolen property, a 4th-degree felony. There's a motion filed on January the 10th. Well, counsel, everything we just talked about is out the door. The ILC order was filed on 1/5/22, and he was put on supervision for 2 years. The supervision has expired. So, defendant's case is dismissed, but you're still required to pay the restitution. As part of the agreement that you made, and the court won't consider the matter for sealing until such time as you've paid the court cost and the restitution. So this was filed after the expiration of the 2 years. It was filed on January the 10th, and so typically if it's filed before the expiration, I'll stay it. But since it expired, the court is required to go ahead and dismiss the case, and you'll be released. It'll still be on the record, though, until you pay your restitution. Free to go.
Thank you, Your Honor. Just still pay the rest. They could come after you financially for that, okay? So get that taken care of, okay?
Case number 21 CR 161, State of Ohio versus Samaria Alaki Jones. Present for the state is Prosecutor Collins, Assistant Prosecutor King. Present on behalf of the defendants, Attorney J. Wagner. And you're Samaria Alaki Jones?
Yes.
All right. This matter is before the court on a hearing. The defendant was put on community control back on April the 12th of, I believe, 22. Yes, 22. And then for a period of 3 years, there was a notification filed on December the 5th that she had not complied with Rules 1, 15, and 18. The 15 was the payment of the court cost, and the Rule 18 was the restitution. Now, what's the status? Now, I think we set it out hoping it might be taken care of.
Your Honor, the defendant just this morning or just a little bit ago did pay her restitution and court costs in full. So at this time, the state would move to dismiss the alleged violations.
Okay. All right, then the violation is dismissed, and you're still on community control, but you're no longer, you've paid all your financial obligations. So, but your period of supervision is 3 years, so it actually is not up for another year and a half, although you could possibly get discharged early if the probation department feels that you're a candidate for that. All right, thank you.
Thank you.
Yes, sir.
right, this is case number 20 CR 238, State of Ohio versus Donna Sue Everhart. Present for the state's Assistant Prosecutor King. Present on behalf of the defendant's attorney, Catherine Hapner. And you are Donna Sue Everhart?
Yes.
All right, Ms. Everhart was placed on community control on March the 3rd of 21 for a third-degree felony. The probation department filed a notice of alleged violations of that on now, let me look here. Okay. Here it is. December the 6th was filed. Court notified the defendant on December the 10th, and matter was set for hearing, and Ms. Hapner was appointed to represent her, and matter set for evidentiary hearing at this time. Now, Ms. Hapner, have you had an opportunity to review these allegations with your client?
I have, and I've spoken or texted with Mr. King also. It's my understanding that Ms. Everhart will admit, and that it's just a desire to keep her on supervision to finish paying off her costs.
All right. So, Ms. Everhart, the allegation is that you were to pay your fine by the end of your term, and that was 3 years. You still owe $4,366.50, and it says you've been making minimal payments of $25 a month. How long has that been done?
Your Honor, she recently started paying, let's see, in December, she paid $100. In January, she paid $75, and she's paid $75 this month also.
So what's the balance now?
So the current balance is $4,147.50.
All right. So when did the payments start? Regular payments start? She's been making that payment since then?
Since the last violation, she upped her payments, yes, Your Honor.
All right.
To $75. It was $25, but she's now doing $75.
All right. So, Ms. Everhart, you have a right to have a hearing to contest that allegation. You have a right to have, the state has to present evidence that proves that you've committed that violation, that you've not paid. Your attorney can cross-examine any witnesses the state presents. You're permitted to present evidence on your own behalf. You're not required to, but you may. In the event that it's found that you have violated the conditions, whether you admit to it or if it's determined after hearing, the court can do one of three things. I can continue your community control under the same conditions. I can continue with additional conditions I think are appropriate. Or the third and the most serious is I could revoke your community control and send you to prison for 36 months. And so you understand the potential consequences if you admit to the violation.
Yes.
And you understand what the violation is alleged.
Yes.
And have you been threatened or promised anything in order to get you to admit to the violation?
No.
All right. And did you admit the violation that was alleged?
Yes.
All right. Well, there's a substantial amount of money there, and one of the problems is making minimal payments. It sometimes at the rate of $25 a month, you would not get it paid off. Are you working?
Yes.
And where do you work?
Wilmington Auto Center.
I'm sorry?
Wilmington Auto Center,
All right. How much are you making?
$17 an hour.
Are you working 40 hours a week?
Yes.
All right. You get any income tax refund this year?
No.
Did you get any in the past?
Not in the past 3 years, 4 years.
Pardon me?
Not in the past 4 years.
All right. Well, see, today is February the 9th, or I'm sorry, the 9th, February the 22nd. I'm going to extend your community control to 5 years. So that will make it expire in March of 26 instead of next year, or instead of March of this year. So that's another 24 months. So to pay it off, plus is about $173 a month. And this is a fine only, okay. And have you paid your court cost?
I'm not sure.
Well, then you haven't. I don't know, has she?
Not to my knowledge, Your Honor.
All right, that's not alleged as a violation, but that's got to be done too. So I'm going to order that you pay $175 a month. Well, I'm just going to make it $200, and then that'll be applied first to cost. First to cost, and then the balance to the fine. Do you know what the costs are, Mr. Bolson?
Not offhand, Your Honor.
All right. Well, so that's going to start March the 1st. Now, if you can get the money together to pay it off earlier, you're probably going to get off the paper. You know, you've done everything else you're supposed to do, but these financial obligations have to be paid. So this just extends you on paper. And you'll have to pay the court costs today. They won't be terrible, a few dollars. But every time you have to be brought into court, it's going to be added to court costs. So I'm setting it at $200 because at that rate, the court costs should be paid off in a couple of months, and then the rest of it can be applied to the fine. But you got to get this taken care of. But the sooner you get it taken care of, the sooner they can get you off the paper, so that you can look forward to the future in 3 years after you get off paper to file for a sealing of the record. So it's in your best interest to do that. So if you do get an income tax refund, or you win the lottery, or you inherit some money, or if you just got a family member or friend that would like to help you out, I would suggest you look into trying to come up with the money, get it paid off, and then you can get off paper, most likely, as long as you continue to comply. Because you've been on paper plenty long enough that you would have been eligible to be released had you paid the cost of the fine. But you're going to have to pay it. All right? Okay, thank you.
Thank you, Your Honor.
Thank you, Honor.
Russell Dunn. All right, it's case number 23 CR 219, State of Ohio versus Russell E. Dunn. Appearing on behalf of the state's Assistant Prosecutor King. Appearing on behalf of the defendant is Attorney Daniel Witt, and you are Russell Eugene Dunn?
Yes.
All right, Mr. Dunn is charged with aggravated possession of methamphetamine, a 5th-degree felony. He has filed a motion for intervention in lieu of conviction. The court ordered a report to be prepared by the probation department, which I have received, and it indicates you're at in treatment with Soda Pink Valley at Brulon.
Yes, sir.
All right, and you've been there since December 19th. Okay.
Yes.
All right.
3 weeks left.
Okay. All right. Well, I have been presented then with a plea of guilty form and an entry. Along with first of all, I do have questions, stipulated questions have been prepared, and I have before me, I see signature of Ms. Witt, and I see Russell Dunn, 22224. You just signed these questions?
Yes, sir.
Everything on this is correct?
Yes.
Okay. All right. Okay, so, Mr. Dunn, your attorney's probably explained this to you, but I have to do it on the record so it's clear that you're aware of what's going on. First of all, you're charged with a felony, and Normally, when a person is convicted of a felony, whether there's a trial or whether they plead guilty, the court imposes a sentence. For this offense, a sentence could be 6 to 12 months imprisonment, could be a $2,500 fine, could be 6 months to 5-year license suspension, or a combination of those. Could also be community control, which is probation. Now, once that happens and that sentence is imposed, that person has a felony record because you're convicted. Now, there is a procedure that's available and you appear to qualify for, which allows a person to plead guilty to the charge, but provided they're in a certified treatment program, which you are, and you're complying with it, and if you comply with certain conditions for a period of up to 5 years imposed by the court, typically I do 2, then upon completion of that, well, first of all, when you plead guilty, when I put you into that program, you're not found guilty. And there's what's called a stay. A stay is a legal term, means basically we just stop the proceedings in time and wait for a report to let us know whether you have completed the program successfully or not. And if you do, then even though you pled guilty, the charge will be dismissed. And while you're in the program, you are not convicted of a felony. Even though you pled guilty, you're not yet convicted because nobody's convicted until there's a sentence imposed. And so you'll be put under what's called supervision by the probation department, and that includes certain conditions that are a lot less and a lot less strict than regular probation. And if you complete those, like I said, then the probation department and the state notify me, and the case is dismissed, and then you become eligible to have your charge sealed. Now, if you fail to comply with those conditions, then the probation department files a written notice of that with the court. There's a hearing, and you have an attorney at that hearing. And if at that time the court finds you guilty, then you're sentenced. And at that time, you do have a felony record. And that sentence, like I said, could be a 9 to 30. I mean, it could be 6 to 12 months in prison, $2,500 fine, and a 6-month to 5-year license suspension. It could also be 5 years of community control or probation. Now, if that happens, those conditions are much more strict, and there are more of them because now you have a felony conviction, and you failed your earlier attempt to comply to get the case dismissed. And so that's the benefit to you is you have the opportunity to get help, assuming you're willing to do it, complete the program and get clean, and comply with the conditions of supervision. And if you do that, then the case is dismissed, even though you pled guilty. Now, the downside for you is this. You don't get to try the program, and then if it doesn't work out, come back to court and say, well, now I want a trial, because this is your last chance to have a trial. So that's the way that process works. Now, you understand that?
Yes, sir.
Okay. Now, I have this plea of guilty form, as I indicated, and on page 3, there's a sentence that reads, I enter this plea voluntarily, and right below that appears to be a signature, Russell Dunn. And is this document, did you just sign this document today?
Yes, sir, I did.
All right. Now, before you signed it, did you talk with, have your attorney go over it with you and explain everything to you?
Yes, sir, I did.
Okay, and you understood it was an agreement to plead guilty? Okay. Did you do this voluntarily?
Yes, sir.
You feel you've been pressured in any way into doing this?
No, sir.
All right. Now, again, the charge, as I said, is aggravated possession of methamphetamine under 2925.11, and the revised code have already explained the conditions to you, or the sentence to you, and what is required. Now, the charge against you reads that on or about August 28, 2023, in Huntington County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, methamphetamine, in violation of that section. Now, have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, and possible defenses you could try to raise in trial, and possible outcomes of a trial with your attorney?
Talk about your case.
Yeah, we talked about it.
Okay. Are you satisfied with her advice and competence?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
Just, inflammatory for my knee. That's it.
For inflammatory relief?
Yeah.
Okay, all right, and inflammatory, all right. But nothing that interferes with your ability to understand what's happening or to express your thoughts accurately or anything like that?
None at all.
All right. Has anyone threatened you to make you do this?
No.
Now, other than being promised to be put into the intervention in lieu of conviction program, has anybody promised you anything?
No.
All right. And do you hold any license or certification from any state governmental agency that regulates any occupation or profession in Ohio?
I do not.
All right. Now, as I said, this is your last chance to stand on a not guilty plea, and so I have to explain your rights to you before I can accept a plea for you to be put into this program. First of all, you have a right to have an attorney. Ms. Witt was appointed to represent you. Now, her obligation wasn't simply to try to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So, if you decide you don't want to do this, that you want to defend against the case, she'll continue to represent you, including a trial if that's what you want. Do you understand that?
Yes.
Right now, under the Constitution, you have a right to a jury trial in this matter, in which 12 people will be selected from a group of citizens that are from Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then the judge would instruct them on the law. And then that jury would decide by a unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. Then you would have what's called a court trial, which means the judge is the one who hears the evidence instead of the jury and applies the law and decides whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that might help your side of the case. You understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certainly going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to testify on your behalf if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, I understand completely.
All right. Now, under the Constitution, you have a privilege against self-incrimination, Mr. Dunn, which means that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yeah, I understand.
Now, under the Constitution, Mr. Dunn, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that you don't have any burden to prove at trial that you're not guilty simply because you've been accused. In fact, you don't have to prove a thing. You don't have to even put on any evidence. It is up to the state to present evidence that proves to the court, to the jury or the court, depending upon which type of trial you've elected to have, that you're guilty. And if it's a jury trial, it has to be unanimous, meaning all 12 would have to agree. And they would have to prove beyond a reasonable doubt every essential element of each offense. Well, that's only one offense here, but of the offense. You understand that?
I understand.
Now, originally you pled not guilty, which denied the allegation in the indictment, denied you committed a crime, and it exercised all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits allegation in the indictment, admits it's a crime, that you committed that crime, and that plea would waive or give up all the rights I've just described except the right to have an attorney. You always have a right to have an attorney no matter what you're pleading. But with that exception, the plea of guilty waives or gives up your right to a jury or court trial, waives or gives up your right to confront witnesses against you and cross-examine through your attorney, waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up You're privileged against self-incrimination because you say you're guilty, that's what's used to find you guilty. The wage gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court, although that's not going to happen here today. And it also waives or gives up any right to file an appeal you may have had up until this point in the case. Now, if you are sentenced to, in the future, a maximum term or under other certain circumstances, you could file an appeal, but any appeal would have to be filed within 30 days of the entry of sentencing being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen, Mr. Dunn?
Huh?
Are you a U.S. citizen?
What that means, Your Honor.
A citizen of the United States?
Yes, I am.
Okay, all right. Now, do you have any questions about the charge or the possible penalties?
No, I do not, Your Honor.
You understand them?
Yes.
Have any questions about the process that we're going through here? What's required of you?
No, I don't have any questions.
You have any questions about the constitutional rights I've explained to you?
No, I do not.
You understand them?
I understand.
All right. And you understand the maximum penalties for the offense if you should be convicted in the future?
Yes, I do.
Okay. You have any questions about anything we've talked about here this morning or this afternoon?
No, I do not.
All right. Is there anything you need to talk with Ms. Witt about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this plea agreement that we've just gone over?
Yes.
All right, then as to the charge, which alleges that on or about August 28, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, a 5th-degree felony, carrying a possible prison term of 6 to 12 months, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. Be seated, please. All right, the court finds on this day in open court, defendant was advised of all of his constitutional rights and made a no intelligent voluntary waiver of those pursuant to Criminal 11 and entered a plea of guilty. The court finds that the defendant's drug usage, alcohol usage, mental illness, or other issue is a factor, were factors that led to the offense with which he has been charged and entered a plea of guilty to. Intervention in lieu of conviction will not demean the seriousness of the offense and would substantially reduce the likelihood that he will engage in a future criminal activity. He is currently in an appropriate certified treatment program at the Rulon Center. He's otherwise eligible for community control sanctions. He's not a repeat or dangerous offender and is otherwise eligible as a matter of law based on the stipulated question signed by both parties. Therefore, it is ordered that the defendant's plea of guilty is hereby accepted. However, there will be no finding at this time of guilt, and all criminal state proceedings will be stayed pending a report from the probation department regarding the defendant's progress in the program. You'll be under community control conditions that have been approved by the court for this program, and probation will go over that with you. You'll be under those conditions for supervision for a period of 2 years. And you'll be required to comply with all those conditions. You're required to complete your intervention plan, which is your substance use and mental health or whatever other issues there are at the Rulon Center, plus any other treatment they recommend once you complete their residential treatment. There'll be aftercare, transitional care, or whatever.
I'm going to, after I finish my, at my reach, I'm going to reach.
Reach, okay, well, good. Well, whatever it is they recommend, that's what you have to do, okay? And now, you also be required to abstain from using any alcohol or drugs for a period of at least a year from today. And in the event that it's alleged that you have violated your treatment plan or any conditions of this order, then there will be a written notice from the probation department. You'll be given a copy. There will be a hearing. You'll be represented by an attorney at that hearing. And in the event that it's found that you have failed to comply, then at that time the court will find you guilty and then will schedule a sentencing hearing to determine the sentence as applicable under the law. You're also ordered to pay the court costs as part of these conditions, as well as any programming fees that may be charged for any programming that the probation requires for you to complete. And you're to pay the court cost, which would include an additional $50 for a sealing fee, because if you complete this program successfully, then I set it for a sealing, and we'll seal your record at that time. Then there will no longer be any record of it because it was dismissed. All right, is there anything further, counsel?
No, Your Honor.
No, Your Honor.
All right, does he need to report down to probation? All right, so you need to go down to probation department because they're going to switch you over from the pretrial supervision, which is now gone. You don't have any of those conditions, house arrest or anything of that nature. And you'll be given the new conditions, and they'll go over those with you. Okay, thank you.
Have a nice day, sir.
You too. Terry Pigg. All right, this is case number 23 CR 209, State of Ohio versus Terry Pigg. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Catherine Hacker. And you are Terry Pigg? Yes. All right, Mr. Pigg has entered a plea of guilty to aggravated possession of methamphetamine in violation of section 2925.11 of the Higher Revised Code of 5th degree felony. The matter was referred to the probation department for a pre-sentence report, which I have received and reviewed. And have each of the attorneys received a summary?
State has, Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
All right. Ms. Hapner?
Thank you, Your Honor. Your Honor, I've spoken with Mr. Pigg. I've also had conversations with Ms. Sturgill. Mr. Pigg is perfectly willing to do drug court. I noted in Ms. Sturgill's letter that there is, he obviously doesn't want to go to prison, and he would much rather do drug court than prison. We also believe that drug court may not be the right fit for him, or for the reasons we have drug court. It's my understanding that he has been clean for approximately 18 months. He works full-time. In fact, he works more than full-time with Turner Construction. I have
Oh, he's working full-time?
Oh, yes. And Your Honor, I have letters from Turner.
Because I had in here he was unemployed.
He began work in October, I believe, for Turner. He's working, and I do have letters confirming his employment. Okay. He works, may I approach?
Oh, okay. It is in the report, in the body of the report, but it was not changed on the face of the report. So they have a template that contains the information from the last one they used. So the officer failed to put that in there. So, okay, it's confirmed as far as I'm concerned.
Yeah, he's working at the Honda project up in Fayette County in Jeffersonville, which it'll be an ongoing project for the next at least 2 or 3 years. The letter from Turner states that he's working 10-hour shifts Monday through Friday, 6 a.m. to 4:30 p.m., and 8 hours on Saturday, 6 a.m. to 2:30 p.m. Mr. Pigg has been a reliable employee, a leader, and has assumed responsibilities with a newly developed crew we have established. He is dependable and arrives at work each day and applies his talents to help this project succeed. Also have a letter from Mickey Davis, who is his foreman. He said that Terry Pigg, he's a wonderful employee and co-worker. He always shows up on time with a great attitude and work ethic. If he is asked to work overtime, he takes the opportunity always, gets along with everyone, and completes each task assigned in a timely manner and as instructed. I feel he is showing great leadership skills. And that's from Mickey Davis. So we would ask, while Mr. Pigg is perfectly willing to do drug court, that sometimes there are issues when working full-time and being in drug court. So we would ask for probation, community control, and if the court feels that drug court is appropriate, then he is perfectly willing to do that. Thank you.
All right, Mr. Pigg, anything you'd like to say?
Your Honor, I just asked for you. Excuse me. I just asked for you to have leniency on me. I'm on my family's God. That's it.
Well, I have a report for probation that you've been testing positive for marijuana, like on 3 different occasions. And I know that it's legal to use, but so is alcohol. And you're not going to be able to do that. And also I have here that you've been struggling with attendance at your meetings with the Recovery Council. And I see in the report that back when you originally were referred there, you started on December 11 of last year, and you were referred back on the 22nd of January because you had missed 5 unexcused absences. And so then on the 7th, you met with Officer Arjima, who sent you back. And are you in counseling now?
Yes, sir.
And when are you going?
Just went Monday night and tonight.
All right. Supposed to go 2 or 3 times a week?
2 times a week.
How many?
2 times a week.
2 times, all right. Well, I thought you were unemployed, and I was going to send you to jail for a few days to let you know that, you know, we're serious about you doing what you need to do. And I still have some concerns about that, but because you're working and because it's a 5th degree felony, I'm going to give you a chance. But if you don't get off the pot and if you don't attend, you know, they report back, you know, we're probably going to put you in a residential program or send you to STAR, and then you're going to lose your job. I don't want you to lose your job, but on the other hand, I can tell you this. It used to be when I first started years ago that my thought was if somebody's working, has a full-time job, and they're paying their bills and everything, then, you know, they're okay, they're going to be good. But now I've learned a lot more how naive that was. We have lots of people that hold down jobs that are what they call functioning addicts. They're taking fentanyl or amphetamines or cocaine or whatever. And eventually it catches up to them. And that full-time job doesn't protect them from, you know, suicide by their own use of drugs, or getting arrested, or you know, dying of overdoses by getting something that's different than what you think it is. So, you know, you've been to prison, and you know, you've done your time, and I don't want to send you back to prison, but let me tell you, you better, you know, start doing everything and keep doing everything that you're told to do, because I'm not going to have a long amount of patience for you, you know, because it looks to me like what you've done is you've gone the last couple of weeks because you knew this was coming up, but back in December and January you weren't. So, you know, that's in the past. It's not going to repeat itself, because if it does, you're not going to like the results. It's the order of the court that you be sentenced to a period of 3 years of community control under supervision of the probation department. Under these conditions, you obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed. You are to be truthful in all statements that you make to the probation department regarding your supervision conditions. You must keep them informed of your residence, place, employment at all times, and it may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility of any jurisdiction, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those without prior written permission. You're not permitted to purchase, possess, use, or have under your control any firearm, ammunition, or dangerous ordnance. And because of your conviction, if you do that, that's committing a felony under both federal and state law that you could be prosecuted for. It's a condition also that you not have any of those or any other weapons while you're on community control in this case. Now, you're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to prepare them for administration or administer them unless you have a lawful prescription. And you have to provide a copy of that to the probation department within 24 hours of receiving it. And you're submitted to drug testing when and as directed. And as far as the marijuana is concerned, it's a condition is that you cannot have a medical marijuana card. That's not a prescription. It's just the state lie that we say to everybody that you know, people can get it. Basically, states just selling them, and so they're not prescriptions; they're an order. And it's basically the same as buying alcohol. And again, you're not allowed to have that either, because if you're just self-medicating, you're not dealing with your addiction issue. You're not permitted to purchase, possess, use, or have in your control any alcoholic beverage. You may not be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, or any other person who has a criminal record, is a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. That applies to any family members other than those you're living with immediately before the offense was committed. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without written permission. You must report any arrest or any conviction, citation, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred for an evaluation or assessment by the probation department for any other treatment, therapy, counseling, training, or other programming, you're to submit to that. If any programming is recommended, you're to enroll in and successfully complete that. Be required to pay the court cost and make payment arrangements to do that. And you'll be required to successfully complete your substance use disorder treatment, and that's abbreviated as SUD in your entry at the Recovery Council, TRC, and any aftercare recommended. Now, by being placed on community control rather than being sent to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed that's under your control where you're found at any time by any officer of the probation department. There will be no fine imposed. There will be no license suspension. You are ordered to pay the cost of prosecution as a substantive order, and if you don't do that or make payment arrangements and pay according to that payment plan, then in addition to be a violation of the rules of your supervision, it would also permit the clerk then to collect that through other means, including levying on bank accounts, wages, earnings, or any other assets you may have. That would also result in an additional 30% collection fee. Now, if you are unable to do that, then the court could permit you to do community service and give you credit in an hourly rate set by the court in each hour you work, or reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you are not complying with this order, then they will file a written notice that with the court, and there will be a hearing at which you'll be entitled to be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and sentence you to between 6 and 12 months in prison, fine you $2,500. If you are violated in part because of conviction for another felony offense and sentenced to prison on that offense, that felony sentence could be ordered to be served consecutively to the sentence in this case, or vice versa. Now, in the event that you do serve a prison term, upon completion of that prison term, the Adult Parole Authority has the option, if they want to exercise it, to put you under post-release control supervision for a period of up to 2 years, which means you'd be supervised under the conditions they set by a probation or parole officer. And if during that period of time they felt that you were not complying, they would, if they found that you had not complied, they could return you to prison to make you serve an additional period of up to, in this case, half of the prison term that was imposed for one or more violations. But if you should commit a new felony, then in addition to whatever sentence a judge in the new felony case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentence in a new case. All right, now, that, and again, you're not in drug court. This is just straight community control. Now, you're no longer under the pretrial supervision terms, including house arrest, but you'll need to report down to the probation department immediately after court for them to arrange a transfer of your case and to give you to a different officer, and then be able to go over the conditions and explain them to you. One other thing I didn't say, well, I did say that you're consenting to a search without a warrant, and you'll need to sign a paper acknowledging that with the probation department. Is there anything further, counsel?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, Paula and Jeremiah Pitzer. All right, we have two cases before the court. Case number 19 CR 27, State of Ohio versus Jeremiah E. Pitzer, and 19 CR 28, State of Ohio versus Paula J. Pitzer. You're Jeremiah Pitzer?
Yes, sir.
You're Paula Pitzer?
Yes, sir.
All right. The state is represented by Assistant Prosecutor King. The defendants were convicted of illegal cultivation of marijuana and placed on community control back on, find it here, thought I wrote it down. I didn't. June the 6th, 2019. The defendants were both discharged from supervision by entry filed on December 16, 2020. They filed their application to seal, I think back in August of 22, and I think then we had to defer that because the time hadn't passed. And I think you filed a new, did you file a new application?
Yeah, we did. I did the year before. I filed the year before he did.
Okay, you did. Oh, okay.
He said as long as
gotcha.
Come back in 1 year, and when we came back, that's how we both
right,
filed.
you had to come back. Yeah. Okay.
Yes.
All right. I did receive a report on each of the defendants indicating that have no other convictions since that time, and anything prior to that was a traffic related. There was a check case on Mrs. Pitzer back in '99 in courthouse. All right, Mr. King, the state did not file any objection. I assume you're not objecting.
That's correct, Your Honor.
All right. All right. All right, then the court will grant the application in each case and order the record to be sealed. We will prepare an entry and file it with the clerk. And you did pay your $50 fees?
Yes.
Okay. And then the clerk will send it out to all the agencies that maintain records, and that takes about up to 30 days for those to be all sealed. What the sealing means is the records are not destroyed. They are kept, but they are inaccessible for inspection. And on the computers in the courthouse, they're blocked, so nobody can access them. But they are kept. Now, in 7 more years, if you want to, you can file to have them expunged, which means they would be physically destroyed. That would involve another filing fee and so forth. You know, I don't know if you need to do that or not. I mean, the effect is the same. If you're asked if you have a criminal record, you say no, because you don't. It's gone. Now, and you're going to be sent a sealed copy which shows that your record was sealed. You want to make several copies of that and keep them in a place that you won't have to worry about them being destroyed or, you know, stolen, or at least make extra copies, put them in different places so that if you do have something like that, you'll still have copies, because you could run into a problem in getting more copies in the future if you needed them, because if you go into the courthouse and say, you know, I need a copy of my case where my record was sealed, they're going to say, well, we don't have a record on you. Yeah. Then you're going to have to file a request to have it reopened. The other caveat is this. This only seals the records in governmental agencies and authorities. It does not seal it for personal or private people or entities. So if there was something in the paper about it, that's not going to be removed. If you have had a record check for insurance or for a job, and the company has that record that did the background for you, that's not ordered to be sealed, and they could use it again if, say, you had came up for renewal on your insurance or something, and they said, well, we show you have this record. That's when you want to use your copy to show them and have them make a copy. Don't give up your original sealed one. You can make copies and give it to them, but don't give up your original so that you do have it. So just to let you know that, you know, there may still be information out there on the internet or in other people's hands that we don't have any jurisdiction over, but it will entitle you to say, I have no criminal record, and if they ask you about this, that's when you show them, well, look, it was sealed.
Okay.
All right, you have any questions?
Will we be able to have that copy when we leave today?
No, we don't have it ready yet. It'll be probably tomorrow.
Okay.
To get it filed, and then they'll mail it to you.
Okay.
You did give me your current mailing address, right?
Yes, are we able to come down and pick it up, though?
Yeah.
Okay.
Yeah, you can
I'm
just stop and tell the
fine.
clerk office when it comes down, if they would let you know. I would say it'll be filed by, I mean, I have drug court tomorrow. She'll prepare it. It may get down there before the end of the day. It's about 2:30, but they may not get to it until tomorrow, depending on what their backlog is. So best thing to do is ask them to give you a call, and then you can come pick it up.
All right.
All right.
Appreciate it.
Thank you. Good.
Thank you.
Congratulations.
Thank you.
Rise.
Ooh.